The court has to do is has to make some findings with regards to the downward departure. And both sides have correctly stated the law that one of the criteria for downward departure has to qualify, and then the court has to make a second determination that it's appropriate. That's a discretionary issue. The court finds, as the state has agreed, that youthful offender status downward departure criteria has been met. The court does not, however, find that the other two downward departures, one is that the youth was too young to appreciate, which is 921.0262K, that the defendant is too young to appreciate. The court finds that that was not proved. The issue with regards to 2J, the unsophisticated manner and the isolated incident and the remorseful, that's a closer call. The court does not find that that qualifies for a downward departure. We've got some disagreement in the evidence as it relates to the defendant's, I'm going to say, contact with the information. There's a lot of terms have been used, access, whether it was viewed or possessed, but the law requires possession, not viewing. The court agrees with the state on that. That's the criteria. And each of these counts carry with it a maximum sentence. They're very severe sentences, severe outcomes, and the reason for it is that the issues that led to the possession, in other words, the creation of these, are extremely serious. People that are here today don't have benefit of the charging document that I have and that's in the PSI. And the descriptions, and we need to understand, these are not pictures. These are videos. Just the 25, not the 10,000, not the 37,000, just the 25 that were charged. Contain with them descriptions that I cannot state in open court. But what I will do is I'll walk down the 25. I'm going to identify the ages of the girls, not the young women, because there are no young women involved here. These are girls. 1 5 to 7-year-old female, 2 to 4-year-old female, 11 to 13-year-old female, 4 to 6-year-old female, 4 to 6-year-old female. These are all separate videos. 2 to 4-year-old female, 13 to 16-year-old female, 9 and 11-year-old female, 5 to 7-year-old female, 5 to 7-year-old female, 6 to 8-year-old female, 4 to 6-year-old female, 7 to 9-year-old female, 7 to 9-year-old female, 5 to 7-year-old female, 8 to 10-year-old female, 4 to 6-year-old female, 9 to 11-year-old female, 5 to 7-year-old female, 4 to 6-year-old female, 4 to 6-year-old female, 7 to 9-year-old female, 7 to 9-year-old female. Every one of these girls that are contained in this had a life-changing event, and that's called sexual assault. The girls in these videos will never, ever be the same. All you have to do is be around this stuff for a little while and you realize that that's true. And that's why these are so serious. These are serious crimes. The court does find that the youthful offender does apply. The court agrees with the state that the limitation, there's an absolute limitation, outside limitation, not only on the DOC, not only on the corrections, but on the total supervision, both incarcerative as well as probation, on youthful offender status to 6 years. And the court agrees that that is not adequate. The court finds, and the court sentences to the court finding that the minimum guidelines, the downward departure, is not appropriate, and in 2 of the cases, the court finds that the criteria cited do not qualify. The court is not applying the downward departure, and as a result of that, the court is required to have the minimum DOC sentence of 97.2 months. There will be an adjudication, and there will be, I'd like to have everyone be quiet in this courtroom, or you're going to be escorted out. It will be followed by 10 years of sex offender probation, and the statutory requirements based upon the designation for sex offender and sex offender probation is the 10-year, no internet access, cost of supervision, GPS monitoring. State believes that the GPS is required under the Jessica Lumsford Act. You guys can argue that if you feel like that's technically not. I know there's a disagreement with that. I'm ordering it at this point. And to forfeit all seized devices. And I will say this to you, that I did take into consideration the defendant's youth. If he hadn't been so young, it would have been a worse sentence. Thank you very much.
I'm sorry, Your Honor. In order, because these are third-degree felonies, may we recommendation?
Yes, we need to break them. We need to break them up. Hold on. Thank you for going through that. So these are the total. Those are the total incarcerative sentence. The court
we put 60 months, Your Honor, on the
I'm
first
sorry.
count.
Say that again.
Your Honor, if we put 60 months on the first count, that would be the 5 years. The second count, the 37.2 that are remaining, consecutive to count 1. So count 2 would be consecutive to 1. If that's acceptable to the court. And then if we go to count 3, it would be 60 months or 5 years of sex offender probation consecutive to counts 1 and 2. And then count 4 would be another 60 months of sex offender probation consecutive to counts 1, 2, and 3. And then counts 5 through 25 would be 60 months of sex offender probation concurrent with each other and concurrent to count 4, if that's acceptable.
Very good. The court will order that. And if the defense has some other suggestion for how to break it up, the court's open to it. I don't think that's, the court would be open to that, but at this point we'll order it as requested by the state.
Thank you, Your Honor.
Okay. Thank you very much.
Over here, Shirley. Here.